Good afternoon. This is Ron Mickens, live from Lakeland, Florida. I hope you had the opportunity to view the first video on fraud upon the court. Fraud upon the court, in which my wife and I has been experiencing for the last 22 years. So hold on. I told you that I was coming back. Ladies and gentlemen, let's recap a little bit, because I want to make sure, make no mistake about it, we want to educate ourselves, and we want to hold judges, law enforcement officers, attorneys accountable for their crimes. Ladies and gentlemen, what I am demonstrating to you, that our judges are worse than the folks that go before them. So stay with me. And it's all about, you know as well as I do, if you think about it, it's all about the blood money. And it started with our state attorney by the name of Jerry here in Polk County. When we first pulled a copy of that fraudulent quitclaim deed that Damron Construction Company, Alan and Debra Damron, and Stewart Title Guaranty Company, Stewart Title of Polk, Elaine P, Canady, Edith, Rewis, and Carey, Harman-Highsmith had conspired and fraudulently created and made, prepared, false notarized, false witness, false delivered, false recorded, fraudulently conveyed our property without our knowledge or consent. Oh, we took this fraudulent quitclaim deed to Jerry Hill's office, and we asked, we pleaded, we requested, we demanded that he do an investigation. This document was strange. It had these strange names on it that we had never seen before. We had never heard of her. Miss Canady and Miss Rewis, two witnesses. Miss Canady, a notary. Stewart Title Guaranty Company, Stewart Title of Polk. Who are these people that had conspired, concerted with the Damrons to fraudulently convey our property? But once we were able to get a copy of the state attorney investigator report, the investigator was Don Pale. I'm calling their names out because I want you to know who these people are. Don Pale. This interview investigation, he was coaching this lady. He was leading her. It was a cover-up from the very beginning. Jerry Hill's office investigator himself, Terry Burgum, Mike Cusick, and Jerry Hill in his investigative role. Not in his prosecutorial role, in his investigative role, because the state attorney can be held liable or sued in his investigative role. They start covering up for Mrs. Rewis, covering up for Mrs. Canady, covering up for Mrs. Highsmith, covering up for Stewart Title of Polk, covering up for Stewart Title Guaranty Company, covering up for Stewart Information Services Corporation, Cisco. And guess what for? Make no mistake about it. They start covering up their fraud for the blood money. For the blood money. This is what he was doing. He was trying to say Mrs. Canady just had made a mistake. It was just a small happenstance, a little small accident. Wasn't no harm really done to anybody. Oh, ladies and gentlemen, Mrs. Canady was a licensed title and insurance agent. She was Stewart Title of Polk issuing agent. She was their notary republic. She was the closing agent. This lady, along with Miss Rewis and Miss Highsmith, on behalf of Stewart County of Polk and Stewart Title Guaranty Company, they fraudulently converted our title. They fraudulently executed a deed. They fraudulently encumbered our property with the mortgage. They fraudulently induced Chase into giving Damron Construction Company a mortgage. This is what the cover-up was all about. The heart of this company, the heartbeat of this company, Mrs. Canady, committing organized fraud, committing these schemes to the fraud for a profit. Jerry Hill began to cover it up. He was covering it up for the blood money. He was trying to protect Stewart Title Information Service Corporation, Stewart Title Guaranty Company, Stewart Title of Polk, Carey, Harman-Highsmith, Elaine P. Canady, Edith, Rewis, Damron Construction Company, Ellen and Debra Damron. He was trying to cover their fraud up. It's a cover-up. It's criminal. And he was doing it for the blood money. Make no mistake about it. So, he started conspiring with the judges when we went to court. Part of the conspiracy was to cover up their crimes, their torts, to cover up the fraud, extricate them from their fraud. This is what it was all about. Judge Strickland found Damron Construction Company guilty of misrepresenting the nature of a quitclaim deed, guilty of fraudulent inducement, guilty of fraud in the execution of the deed, fraud in the formation and performance of the construction contract. Jerry Hill, the state attorney, and Judge Strickland conspired to extricate them from this fraud, to circumvent it, to avert it, to avoid it, to annul their fraud under false pretenses. Let's pretend that they never committed these fraudulent acts. Oh, he didn't commit these fraudulent acts by himself. Alan and Debra Damron and Damron Construction Company didn't commit these fraudulent acts by themselves. They couldn't commit any of these fraudulent acts without Stewart Title Guaranty Company, Stewart Title of Polk, Carey, Harman-Highsmith, Elaine P. Canady, and Edith Rewis. So they conspired to cover it up. And the way Judge Strickland decided to cover it up, he grabbed this judgment / remedy out of the sky and said, this is how we're going to resolve this matter. We want you, Ron and Gloria Mickens, to permit Damron Construction Company or the other stipulated claimant, which was Stewart Title Guaranty Company. We want you to permit them to purchase you a lot for no less than $60,000 in any location you choose. But we want you, in exchange, to deed over the house and the lot. But not only that, we want you to hold them harmless, release them from all their liabilities. We want you to accept that $60,000 lot in exchange for your claims for damages, fees, and costs. Now, Judge Strickland had voided the quitclaim deed ab initio because Damron Construction Company had executed it in violation of Florida Statute 68901. That was fraud. So it was void from the beginning. We had a claim for fraud, ejectment, breach of contract, which we were entitled to damages. We was entitled to our attorney fees and costs. Now, when we amended our complaint for him to enter a final judgment, this is what we asked for. We asked for $3,906,000 in compensatory damages, and we asked for $7 million in punitive damages. So this is almost $11 million that the judge is asking us to give up, extricate these Damrons, the Damrons, from their fraud. So we said, no, we can't do that. This doesn't make any sense. We came here to hold these people accountable for what they did to us. They filed a lawsuit as the plaintiff. We had to file as the counter plaintiff. They stole our property. They never had any intention of constructing us a home. They treated us like dirt. Okay, I'm not going to get into that part of it. But anyway, you see the continuation of the cover-up. The cover-up is for the blood money. You got to think about it. If I'm going to save Stewart Title Information Service Corporation, millions of dollars. I'm not going to do that for nothing. He's doing it for the blood money. Jerry Hill, Judge Strickland, is doing it for the blood money. They're not violating the law. They're not conspiring and covering up crimes for nothing. They got a purpose for it. They're not risking their careers and their livelihood for nothing. They're doing it for the blood money. We were entitled to that approximately $11 million based on those 5 claims. But we have an additional 15 or more claims that we are entitled to prosecute and obtain a judgment against Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Rewis, Harman-Highsmith, and the Damrons. They were indispensable parties. They had to be joined. So we were going to be asking for $100 million. But on the other hand, you got the state attorney and you got Judge Strickland at this point conspiring to circumvent our claims for damages. Our house and the lot that we won by windfall because of their fraud. Here you got the state attorney, a law enforcement officer, and you got a judge using false pretenses, trying to extricate these people, remove them from their crimes and their lot, not hold them liable and responsible, not hold them accountable. That's against the law. They caused us all kinds of injuries and we were damaged. So we were entitled to this relief as a matter of law. So the conspiracy and the cover-up continues because Judge Strickland decides that he's going to use recusal or disqualification as a pretext to avoid rendering us a final judgment on the 5 claims in which he had adjudicated. The 2nd District Court of Appeal had reversed or overturned this frivolous judgment, this judgment that he had entered without having jurisdiction. They were required to overturn it because it was unsupported by the evidence, unsupported by the pleadings, unsupported by the record, and objected to by both parties. So he refused to give Ron and Gloria Mickens the relief that we were entitled to. This was an attempt to steal our money. It was an attempt to collect the blood money from Stewart Information Service Corporation. So we go on to Judge Moore. The conspiracy continues. Judge Moore makes this material misrepresentation. in her order on motion for final judgment. And I'm paraphrasing somewhat because this is a review. But she fraudulently misrepresented that. And I quote, she said, though the Mickens could have been much clearer as to their desire for rescission and their attempts to rescind the contract, the Mickens are before the court pro se. And she found that the Mickens had made sufficient arguments in their counterclaim and arguments before the court to state a cause of action for rescission. So therefore, Judge Moore was telling us that she was replacing our judgment on the merits for our fraud, cancellation of deed, quiet title, ejectment, and breach of construction contract action. Ladies and gentlemen, this is a crime. She's unlawfully overturning, reversing, annulling, aborting, dismissing, ignoring, omitting, replacing Judge Strickland's finding. We didn't invoke her jurisdiction, neither party. Both parties objected to rescission. It was based on a lie. It was our desire to give up a potential $100 million judgment. Remember, the judge said that all of our claims for damages, fees, and costs was granted. If we won a judgment for fraud against Alan Damron and had the deed voided ab initio against Alan Damron Construction Company, we were going to prevail on our claims for fraud, negligence, conspiracy, all the other 15 claims against Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Rewis, and Highsmith. His findings was the law of the case. We were going to be able to clear the table, walk the table. All of our claims was undeniable, indisputable. Now, Judge Moore, joining the conspiracy, going to replace our pleadings, our claims, 20 of them, with rescission. And it's to cover up, once again, because she says she's getting us rescission, but she's going to order us to pay Alan Damron Construction Company for the cost of materials and labor. So we're going to exchange, or she's going to replace 20 claims in lieu of one claim in which she's going to order us without jurisdiction to pay Alan Damron Construction Company. You see what they're doing? They're extricating the Damrons and his co-conspirators, Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Rewis, and Highsmith, from their fraud. So, the conspiracy and the cover-up continues for the blood money. And because we're African American, that's what it's about. It's for the blood money. And because we are a black male and female couple. Their fraud is undeniable. Judge Strickland and Judge Moore determined that the Damrons committed fraud. Now, the state attorney don't do anything, not to my knowledge, to the Damrons. He's going to cover up Stewart Title Guaranty Company, Stewart Title of Polk, Canady, and Rewis fraud. He can't do that. You see the cover-up. You see the determination, the rulings that Judge Moore and Judge Strickland has entered. That's the law. Rescission is a crime. It ain't even available. This is fraud on the court. We gotta hold these judges, state attorney, law enforcement officers accountable. It's theft. It's theft of our money that we were entitled to. They doing it for the blood money, and because we are an African American couple. But as this thing goes on, it gets worse. If you think what Judge Moore did was worse, what made it worse and what caused the Second District Court of Appeal join the conspiracy, they affirmed Judge Moore fraudulent rescission judgment. They affirmed it. That was a death sentence for us. Stay with me. It put us in a totally defenseless position. We had no fence. Rescission became the law of the case. Judge Moore fraudulent misrepresentation that we desired, essentially desired and sought rescission, became the law of the case. When the second DCA affirmed rescission, they were unlawfully and fraudulently authorizing the lower court to overturn, to reverse, to abandon, to annul, to replace, to omit, to abort Judge Strickland's findings on the merits of our claims. They were doing this unlawfully, the same as what Judge Moore had done. But when they affirmed it, we had no rights. They had reduced us to nothing. We had no standings. They forced us to go along while they licensed or authorized the lower court judges to do anything they choose, to reverse or to fabricate, create facts, issues, claims, orders in the favor of Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Rewis, and Harman-Highsmith, and the Damrons. In other words, they're licensing or authorizing the lower court to turn the innocent into being considered as the guilty one, and the guilty to be considered as the innocent, the losers to be considered being the winners, and the winners being considered as the losers. This is fraud upon the court. All for the blood money. money that we had prevailed on the merits. But now they're going to fabricate. They're going to lynch us, degrade, humiliate, demean. They're going to mortify, abase. They're going to do everything in the book to destroy us. Can you imagine this? Stewart Title Guaranty Company? Stewart Title of Polk? Let's start with Stewart Title Guaranty Company. Got an action, a so-called foreclosure action, judgment against Ron and Gloria Mickens, the company who induced Chase Federal into encumbering our property with a mortgage on behalf of Damron Construction Company, not Ron and Gloria Mickens. They had to pay Chase off with insurance proceeds because of their fraud. They dropped Damron Construction Company from the lawsuit. So who do they foreclose on? We were not in a mortgage with them. And they had admitted to their fraud to Chase. They were not a bona fide purchaser. They know Miss Canady had fraudulently encumbered our property. Now, you be the judge. How can they have a foreclosure action against Ron and Gloria Mickens? That's a crime. Right now, I got the deeds here in front of me. Damron Construction Company, after being found guilty of fraud and the judge voided the deed ab initio, he was dropped from the lawsuit, but he passed on a special warranty deed to Stewart Title Guaranty Company. And Stewart Title Guaranty Company passed on a special warranty deed to a family or a couple by the name of Dan and Angela Laird. Here's Stewart Title committing a criminal act, and the Damrons criminal act transferring property that they don't own. Here, the fraud is being covered up by Jerry Hill, by Judge Strickland, by Judge Moore, and the 2nd District Court of Appeal. They set us up with these frivolous judgments. Can you imagine? Stewart Title Guaranty Company? Who else Stewart Title Guaranty Company? We never had any dealings with this company. We never even heard of them. Stewart Title of Polk. Miss Canady, Miss Rewis, can you imagine? Judge Constein was their man. He was the man that was creating all these fraudulent judgments for them. He and Judge Alcott entered a judgment against us on behalf of Canady, Rewis, and Stewart Title of Polk. Can you imagine that? Who are these people? These people committed the fraud with Damron. We never heard of them. How are they going to get a judgment against Ron and Gloria Mickens? Stay with me. This is fraud upon the court. It's a cover-up. You're going to give Damron Construction Company a judgment based on a fraudulent misrepresentation by Judge Moore, saying that we essentially desired and sought rescission, and say because we wouldn't participate in her rescission judgment, saying that we failed to permit discovery because we wouldn't join in to this fraud against ourselves. They want to create this new evidence. The trial It's been over, been had. Verdicts and everything in. They talking about allowing two contractors to come out and assess the cost of materials and labor. No, we're not participating in that. If we participate in that, that's like we're consenting and participating in rescission. That's a crime against us. So you understand, how you going to give somebody that committed fraud against us, now all of a sudden you turning this thing around to they're the innocent one and we are the guilty one. Oh, you wouldn't believe what these people were doing to us and how they dehumanized us. They humbled us. They embarrassed us. They harassed us. They reduced us to nothing. Now, of course, I'm not changing the subject either, because this is a part of it. I was an assistant principal in the Polk County school system. So they're going to teach me a lesson. I don't stand up for my rights against them. So they attacked me in my employment. They terminated me without due process, equal protection, freedom of speech. Let me kind of break it down and slow it down a little bit. Because I want you to help me expose this and hold these people accountable. These are judges acting outside the law. They don't have immunity. This is treason. Treason against the Constitution. Treason against us all. I can't fathom judges committing these kinds of crimes and torts. Okay. At the school board meeting, my wife and we both pleaded with the school board to afford me my procedural and substantive due process right before they made a decision to terminate my contract as an assistant principal. I had an attorney also join me and my wife, and he explained to the school board that they were being asked to terminate someone's contract without any facts. They didn't have any facts to base the decision on. Some bare-bone accusation that I had committed misconduct. My attorney told him, said, y'all don't know whether he's being alleged of eating some student lunch, throwing a rock. They didn't have nothing to base the decision on. The school board attorney said, well, Mr. Mickens has asked for a hearing. My attorney said, hold. The hearing is supposed to be before you got the cart by the horse. You're supposed to afford the person due process before you take the action. School superintendent, he butted in. School superintendent is the one that had recommended that my contract be terminated. So he told the school board that he wanted to assure them that due process had been followed every step of the way. He was responsible and he was liable. And he had Lane Trone, Don Wilson, popular law firm, advised him every step of the way. And he just wanted to assure the board that due process had been followed. I pleaded with the board. I told the board, afford me my procedure and my substantive due process rights. And if they found that I had committed misconduct or insubordination or whatever, the school board could terminate me, whatever wrong they could terminate me, I would accept responsibilities and to terminate me. That's what I said to them. But no, well, the superintendent kind of hooked the school board somewhat and said, oh, we get him a teacher's position. We said no. I said no. If I could teach, I could still be an administrator. I'm entitled to due process before. But anyway, make a long story short, the school board terminated me as assistant principal. The administrative law judge hearing was continued 6 times. So it took 33 months before we got the administrative law judge recommended order. Administrative law judge, and this is just the abstract of his determination, but he ruled that the superintendent and his administrators was not credible. They were not believable. That they had conducted an uninterrupted sequence of abuse against me. That they had terminated me based on a non-existent factual allegation. Let me repeat that again. A non-existent factual allegation. That their conduct was manifold and egregious. All the findings of facts and conclusions of law was overwhelmingly in my favor. The school board adopted these findings of facts and conclusions of law in their entirety. So they had no defense. Also, the EEOC had ruled in my favor. I think they took at least a dozen or more employees outside of my protected class, and they determined that they were all had been given notice, hearing, and just cause has been established before they were disciplined or terminated. This shows where I was denied due process. Florida Statute Chapter 231.36 requires that I be afforded notice, hearing, and just cause before they could discipline me or terminate me. Administrative law judge had told me in a telephone conference on one occasion while we was waiting for the hearing that it was impossible for the school board to terminate me without due process. He didn't care what the school board had did that particular night or said. I was not terminated. And he was correct. This shows where I was treated unequal. This is unequal treatment. This is a deprivation of my equal protection rights. It's clear. Other employees was given these due process and equal protection rights before. The Department of Labor and Employment Security determined that the school board had terminated me based on alleged misconduct. Alleged. Information that the school board provided them didn't support a charge of misconduct. Alleged misconduct. Isn't that without due process and equal protection? Education Practice Commission ruled in my favor. Now, just to show you how they're still perpetuating this fraud upon the court against me in this county. I go to federal court. Here, let me explain this again. When you have these type cases and fraud on the court is being perpetrated by the judges, they require that your lawyer be in concert with them. They require your lawyer to lead the charge against you. Okay, I understood my due process, my due process and equal protection right pretty well. So I saw what was going on, and especially what really confirmed it when they start dismissing the superintendent, and they start doing stuff like that, and the district court judge gonna order the magistrate judge to do this report and recommendation. So the magistrate judge come back and say he's recommending to the district court judge that he dismissed all my due process and equal protection claims, my First Amendment claims. He said that I was afforded due process and equal protection, my rights under Title 7, retaliation, discrimination. So the school board was entitled to a summary judgment because this 33-month substantially delayed malicious prosecution hearing was due process. And he said that he was using McKinney versus Pay as the authority. I go and read McKinney versus Pay. First thing I read is that McKinney was given 13 charges in a 3-day hearing before he was disciplined. Brown versus the Board of Education versus Laudermill, Supreme Court precedent case, requires some type of due process, some type of hearing before you take the action. The Constitution says that you can't deprive me of my life, liberty, and property, interest in my employment without due process. The 11th Circuit, Hamilton versus Ham, or Arlington versus Ham, excuse me, said the due process prevents mistaken, unjustified, or wrongful termination. It comes before you take the action. Chapter 231, Florida statute, the ethics codes, all says the same thing. But now you got this judge saying that I was afforded due process. So, ladies and gentlemen, they never gave me a job back. I could have never been without a job. Never gave me a job. Didn't even reinstate me. Didn't want me to have any money. Period. Because I was standing up for my rights. Here's the cover-up again. Granting them a summary judgment. Extricating them from their wrongdoing. They didn't commit misconduct. Give you an example of that. They required me to undergo psychological testing without authority and without a factual basis. I was permitted to go to trial with this claim. I prevailed. The jury awarded me $300,000 because I prevailed. I won that claim. But the judge turned around and reversed it, overturned it. Now, to make a long story short, if you're going to reverse something, you're going to have to be able to show that the school board had authority and that they had a factual basis. You see the fraud on the court? You see the conspiracy to deprive me of everything? Isolate me in the community? Stigmatize and defame my reputation, my name? Ladies and gentlemen, send a sheriff SWAT team out to murder me? All these orders in here are crimes. Fraudulently created, fabricated judgment on behalf of Damron Construction Company, Debra Damron, Stewart Title of Polk, Canady, Rewis, Stewart Title Guaranty Company. All for the blood money. I hope you understand it, where I'm coming from. They committed fraud, but Jerry Hill started it. He started from the very beginning. So he needed the courts to extricate, to cover up all of their crimes. These people were criminals. Stewart Title Guaranty Company know 10 times more than I do. Talk to the investigator from Houston, Texas. Oh, he was down here. They had a hearing on Miss Highsmith. They know all the fraud, grand theft, and everything else that those people were involved in there. But they're here covering all of this up when it comes to Ron and Gloria Mickens. Covering up that this lady was the heartbeat of Stewart Title of Polk, Stewart Title Guaranty Company, and Cisco. She was their issuing agent. She committed the most egregious act that a title insurance agent could possibly commit. That's what it's all about. It's not that complicated to understand. But what's so heartbreaking, what's so disappointing, is that we got judges all joined this conspiracy for the blood money. Don't be duped. This is what it's all about. They set me up to be murdered. Make no mistake about it. They knew exactly what they were doing from the moment that we took that fraudulent quitclaim deed, that Miss Canady had took the lead in creating, making, preparing, executing, witnessing, false witnessing, false notarizing, false delivering, false recording, conveying our property, slandering our title, converting our title, inducing chase, fraudulent inducement, fraudulent encumberment. Put the whole company, whole corporation at risk of having their license revoked. So this is what this cover-up is all about. Ladies and gentlemen, I know you're getting excited, but we got to expose this corruption. We got to hold our judges accountable. Now I'm coming back because I got some of these specific and detailed stories that I want to share with you. My wife and I has been chosen to stand up. We survived all the harassment, all the intimidations, all the threats. But you got to get involved. It's time for a change. So, when you view this video, please communicate it to what's happening to someone. Pass it on. In the meantime, I will be back, and I'm going to continue to blow you away. I will talk with you later.